Hello everyone, this is Yatishri Upadhyay on law preparation. Today we are going to discuss questions of IPC asked in Uttarakhand Civil Judge 2013 preliminary examination. Question number 1. In which one of the following cases Lord Sumner said they also serve who stand and wait? Here options are Mehboob Shah versus Emperor, Inder Singh versus Emperor, Barindra Kumar Ghosh versus Emperor, and D. None of the above. Now this question is related to section 34 of the code, which is about common intention and which required involvement of more than one person. It is not an offense in itself, but it makes an offense in association with other sections punishable. So here answer is Mehboob Shah versus Emperor. Question number 2. Local laws mentioned under section 42 of the Indian Penal Code 1860 means a law applicable to A. Whole of India, a particular part of India, any part of India, or D. None of the above. Now section 42 talks about local laws, which means the laws which are applicable in a particular part of India. So here the answer is a particular part of India. Now we'll discuss section 41 of the code, which is about special laws. Special laws which are applicable on special subject such as TADA, POTA, POCSO Act, etc. POCSO means Protection of Children from Sexual Offences Act. And earlier local laws means like UPLRC, MPLRC, which are applicable in their respective states only. Next, question number 3. Good faith within the meaning of IPC means options: an act done with due care and attention, an actual belief that the act done is not contrary to law, an act is in fact done honestly, an act done under bona fide belief. Here good faith is defined under section 52 of the IPC, and which is defined under section 52 and says an act done with due care and attention is a good faith. So here answer is A, which is an act done with due care and attention. Next, question number 4. Who prepared the first draft of Indian Penal Code? Options: Canning, Stephen, Bentinck, or Macaulay. So answer is Lord Macaulay, who has prepared the first draft of Indian Penal Code. Question number 5. In which of the following sections of IPC preparation is punishable? Options: section 121, 125, 398 of the code, section 122, 125, 399 of the code, section 122, 126, 399, or section 121, 126 and 398 of the code. Generally, preparation is not considered as punishable, but there are some exceptions to it. So answer is C, which is section 122, 126 and 399 of the IPC. The preparation of these offences is punishable under the code. Next, question number 6. McNaughton case is related to which of the following section of IPC? Options: section 83, section 84, section 85, or section 86. So answer is B, that is section 84. Question number 7. Which of the following case is known as Nasik conspiracy case? Options: Vinayak Damodar Savarkar case, Bal Gangadhar Tilak's case, Madhu Limaya's case, or none of the above. Here the answer is Vinayak Damodar Savarkar's case. Question number 8. Which one of the following set of sections of IPC provides for the right of private defense? Section 107 to 120, section 121 to 133, section 76 to 105, or section 96 to 106. Well, right of private defense is provided under chapter 4 of the code, which is under section 96 to 106, and right of private defense is of body or property of oneself or the others. So here the answer is 96 to 106. Next, question number 9. A having joint property with Z in a horse, intending thereby to cause wrongful loss to Z, shoots the horse, under what section of IPC A shall be charged with? Options are section 426, section 429, section 437 or section 438. Here the offence committed is mischief, and which is defined under section 425 and which is punishable under section 426. So here the answer is option A, which is section 426. Question number 10. To which one of the following section of IPC Hicklin rule is related to? Options are section 292, 291, section 290, section 294. Here answer is section 292. Question number 11. A fires on a crowd for no reasons, as a result of which B dies. What offence has A committed? It is an illustration of section 300. Options are A. Culpable homicide not amounting to murder, grievous hurt, murder, none of the above. Here answer is murder. That is option number C. Which of the following are the essential elements of offence of grievous hurt? Options are emasculation, privation of any member or joint, permanent disfiguration of head or face, or D, all of the above. Now, section 320 defines grievous hurt, and it is an offence punishable under section 325, and the elements are total 8 in number, which constitute a grievous hurt. The grievous hurt is not an offence in itself, but voluntarily causing grievous hurt is an offence which is provided under section 322 and punishable under section. So here the answer is D, all of the above. Question number 13. A voluntarily throws into a river a ring belonging to Z with the intention to cause loss to Z. A has committed the offence of, options are theft, robbery, cheating, mischief. Here the offence is mischief, which is under section 425. As we have discussed, its punishment under section 426 in a previous question. So answer is mischief. What should be the age of minor to constitute the offence of kidnapping? Options are 16 years, 18 years, below 16 years in case of male and below 18 years in case of female, below 18 years in case of male and below 21 years in case of female. Well, kidnapping is defined under section 359, 360 as kidnapping from India, and 361 as kidnapping from lawful guardianship. So here kidnapping of a minor in case of, so here in case of male the age of a minor is 16 years, and in case of female the age of minor is 18 years. So here the answer is C, that is 16 years in case of male and below 18 years in case of female. Answer is this. Next, which one of the following is a case decided by federal court on section 124A of the Indian Penal Code? Options are Kedarnath versus State, Niharendu Dutt versus Emperor, Empress versus Bal Gangadhar Tilak, D, Emperor versus Sadashiv Narayan. And answer is option number B, Niharendu Dutt versus Emperor. Question number 16. To which of the following offences the Apex Court judgment in Abhyanand Mishra versus State of Bihar is related to? Options are Section 420 and 511 of IPC, Section 511 of IPC only, Section 420 of IPC only, none of the above. So your answer is Section 420 and 511 of IPC, that is A. Question number 17. Under which one of the following sections of IPC rash and negligent driving of vehicle on public way is an offence? Options are Section 278, Section 279, Section 273, Section 280. Answer is option number B, that is 279. Question number 18. Unlawful assembly is defined in which of the following sections of IPC? Options are Section 34, Section 149, Section 146, none of the above. Now, Section 34 talks about common intention. Section 144 talks about common object. And Section 146 is about writing. So answer is none of the above. Option number D. Question number 19. Section 153AA has been inserted in IPC 1860 by which of the following Criminal Law Amendment Act? Options are Act of 2001, Act of 2003, Act of 2005, Act of 2006. So your answer is Act of 2005. Question number 20. X along with 4 other armed hoodlums seizes the child of Y and threatens to kill him. Options are robbery, dacoity, attempt to murder and theft. Well, robbery is defined under section 390. Dacoity is defined under 391. And attempt to murder is defined under 307 of IPC, and theft is under 378. So here answer is dacoity, option number B, which requires minimum 5 persons. Question number 21. In which one of the following cases section 303 of IPC was declared unconstitutional? Options are Meetu versus State of Punjab, Bachchan Singh versus State of Punjab, Jagdish versus State of MP, and none of the above. Your answer is Meetu versus State of Punjab. Question number 22. A mixed sugar in B's food knowing it to be arsenic. B did not take that food. What offence has A committed? Options are A has committed no offence, A is guilty for assault, A is not guilty for assault, or A is guilty for attempt to murder. Here A has committed the offence of attempt to murder. So A is guilty of murder. Answer is D. Question number 23. The offence of section 361 of the IPC is basically against, options are family, society, any person, or lawful guardian. As we have discussed earlier that section 361 of IPC is an offence, is a kidnapping of from lawful guardianship. So the answer is option number D, that is lawful guardianship. Question number 24. A has consensual sexual relations with Z's wife. She gives to A a valuable property which A knows to belongs to her husband Z, and she has no authority from Z to give. A takes the property dishonestly. Which one of the following offences has been committed by A? Options are criminal breach of trust, theft and criminal breach of trust, theft, criminal misappropriation. Answer is option number C, that is theft. This is an illustration under section 378 which defines theft. So these were the questions discussed in Uttarakhand Civil Judge Preliminary Examination 2013. Thank you for watching.